Good morning, everyone. Thanks for joining us on this Friday morning. The sun is out. We are at the last day of the conference. Everyone's a bit down. Party was yesterday, right? We are super happy now that you found your way into the classroom, because we will have 3 fantastic award-winning papers that we want to bring to you. And these are the winners of the so-called Top Policy Provocations. This title is credited to Michael Weil, who always has good ideas about how to call an award that is not an academic award in a fancy way, because we organize every year an academic event which is called the Privacy Law Scholars Conference Europe. It is a very cool conference that is modeled after a conference in the US, the PLSC US, and we are discussing and workshopping papers. It is not a conference where big heads present papers, but where we are actually all reading the drafts of the papers. The author will be present, but not presenting. There will be a discussant designated, and then basically everybody in the room will start making contributions, and we will discuss this paper from the different people that are in this room. This is lovely because you are really getting valid and strong feedback. It's good for emerging and junior faculty and researchers, but it is also really a good sounding room, let's say, for researchers that are already much more seasoned. And so we started this new initiative of the Top Policy Provocations last year. That was a bit a dry run. And here they are, our winners. And I would like to briefly introduce you to the people in the room or on the panel. So we have first Joanna Mazur from Warsaw University. And she has co-authored a paper that together with Claudio Novelli and Zuzanna Choińska. And this paper is exploring whether data protection authorities should enforce the AI Act. Next to her is Ruoxin, and she is a PhD at VUB, a very good stable, with where many new emerging talents in data protection, privacy, and fundamental rights governance of new technologies comes from. And I can very much recommend her paper, Beyond Individual Privacy, a layered diagnostic model for analyzing genetic data governance. And next to them, we have actually now Dave and Christopher Millard. So they both are working at Queen Mary University and the cloud computing project. Cloud legal project, thank you. And they are churning out every year like a really massive paper that is dealing with the most burning issues of data flows and cloud governance more broadly. And in the middle between them, we have Romain Robert, and I'm very grateful because he is joining us as a policymaker in order to give a reflection on the top policy papers, provocations. And Romain took it on himself to read all these contributions during his vacation. So we are exceedingly grateful for his devotion today to this panel. I'm Christina Irion. I'm associate professor at the University of Amsterdam. I'm glad to moderate this panel today. And without further ado, we are going to hear the first presentation. And we are starting with Joanna. The floor is yours. If you want to stand, you can also have this one. Like you want to.
Yeah, I think I will sit because there will be too much movement, I suppose, if we all start to stand up. So, hi everyone, thank you for coming and thank you for organizing this panel. And yeah, I'm really glad I have this fantastic experience of being here. And as you already know, I'm going to present this paper we co-authored, which is also a part of a bigger research project on the enforcement of EU law in concerning digital markets. And I will speak about it a little bit later, but no. Oh, okay. So we had 3 goals when we started this research. So firstly, we wanted to establish what are the provisions in the AI Act which actually refer to data protection authorities, to what an extent it is somehow determined, what kind of participation in the enforcement systems under the AI Act the DPAs will have. Then, and this is like the the core part of the paper, we wanted to establish what is actually the current level of activity of DPAs regarding the enforcement concerning AI. And then finally, on the basis of this, answering the second question, we wanted to formulate some recommendations for how it actually should, how the enforcement should be shaped and what should be the role of the DPAs under the AI Act. And starting with answering this first question, the most descriptive one, actually there is not much that is certain under the AI Act in terms of what is the role of DPAs. We now know that after some reluctance on the side of the Polish government to include DPAs in the list of authorities protecting fundamental rights, now all of the member states actually do include DPAs on their list of authorities protecting fundamental rights under Article 77 of the AI Act. So this is something that not only we know from the legal act, but we also know now from the practice. But then the other elements are more uncertain. So we have very strong suggestion, and or this is what I would argue under Article 74, paragraph 8, that the DPAs should enforce the AI Act with regard to certain high-risk systems, which are enumerated in Annex 3, but only to with regard to selected ones. Then I guess it would be logical to have the DPAs enforce the right to explanation because of the relation between this right to explanation under the AI Act and under the GDPR, but it is not certain in terms of how it is regulated in the AI Act. And then we have some links which result from mentioning data processing in provisions such as, for example, Article 50 about emotion recognition, biometric categorization systems. We have some solutions concerning regulatory sandboxes where the DPAs are somehow mentioned, but also not like directly strictly regulated. So there is, to sum up, a lot of discretion on the side of the member states in terms of how they shape the role of DPAs under the AI Act. Even though when we look at who is supposed to enforce the AI Act with regard to the EU institutions, we know that it is EDPS, and therefore this might be a strong suggestion of how actually DPAs should be included in the AI Act enforcement models also at the level of the member states. But then, like, should they be, right? So what we did, and this was the most difficult part of this study, we tried to collect data on all of the data protection authorities and the way that they so far enforced the GDPR with regard to cases where AI was somehow present. The challenges that we faced began with like the most basic one and most difficult one to address. So in the cases of some DPAs, we were not able to access some of the decisions. We experienced a lot of technical challenges, and there is a reason why I'm talking about this. I will come back to this later. So I'm not only complaining, you know, there will be more suggestions about what we could do with that later on. So technical challenges concerning poor quality of search functions or lack of search functions on the websites of certain DPAs, decisions being published in non-searchable formats. And then actually in the light of these technical challenges, some linguistic challenges happen to be less serious because thanks to the official translations, we could use these phrases for the purpose of search. We used a lot of automated translation tools in order to identify the decisions which concerned AI or automated decision making. And these, which you can't see, but I will explain it, we decided to collect 5 different types of data. So firstly, whether AI is directly or somehow mentioned or could be included in the blacklist of operations subjected to data protection impact assessments under the national blacklists. Then we're looking for 2 types of decisions. So decisions which would somehow mention artificial intelligence, and then decisions which would concern automated decision making. And this was like the main part of our study, like the most important types of data that we're looking for. And then 2 additional ones were the number of search results on the website concerning AI and the number of results concerning artificial intelligence in the annual reports of the DPAs. And in order to somehow differentiate the way of these types of data in our final results, we calculated the results concerning the decisions as half of the final score of the assessment of the level of activity of the DPA, and the other 3 types of data that we're collecting constituted the other half, right? So the way of the decisions which are legally binding and the opinions that the DPAs provided concerning some of the legal acts adopted at the level of the member states were given higher weight than the 3 other types of data that we're collecting. And these are the final results in the form of a table, which used to be colorful, but because the journal didn't allow us to have colors, it's not anymore. So I will have to explain the results using more descriptive manner. We, on the basis of the results of this index, this weighted index that we constructed, we distinguish 4 different groups of the enforcers. The first group, which comprises Austria, France, Germany, Italy, the Netherlands, and Spain. These are the most active enforcers. So in their case, we were able to identify more than 1 decision in both the category of AI-related decisions and the category of automated decision-making decisions related to these provisions of the GDPR. And also, these DPAs were very active in terms of other variables that we're collecting. They had, for example, dedicated web pages about how data protection and AI are related, how should we use AI in the light of the GDPR and so on. Then we have this most numerous group of active enforcers. Here we have Belgium, Bulgaria, Denmark, Finland, Greece, Latvia, Luxembourg, Portugal, Slovenia, and Sweden. In the case of which there was at least 1 decision and more than 1 decision in another category. So we're not able to find as many decisions, right, as with regard to very active enforcers, but still these were the DPAs with regard to whom not only these decisions were present, but also we were able to identify or they achieved quite high scores with regard to other variables. And this is the optimistic part, and I would like to stress that altogether we're seeing here 16 of the DPAs, so this seems to be quite good result. Because, yeah, now we go to less optimistic results. So the reluctant enforcers, in the case of which we are not able to identify more than 1 decision in any of the categories of decisions that we are looking for. And in this group, we have Czech Republic, Hungary, and Ireland. And then the inert enforcers, which unfortunately, and I was really hoping that we're gonna disprove it, but constitutes in a big part of the member states from Eastern or Central Eastern Europe. So Croatia, Estonia, Malta, Poland, Cyprus, Lithuania, and Romania, in the case of which we were not able to, either we identified 1 decisions and they had poor results in other aspects, or we're not able to identify any relevant decision. So on the basis of these, going back to more optimistic part on the previous slide, we argue that actually it would make sense, considering this experience that at least 16 of the DPAs have with regard to the enforcement concerning AI and automated decision-making, to designate them as market surveillance authorities with regard to all of the high-risk systems listed in Annex 3, not only the ones that are proposed in Article 74, paragraph 8. Then we also argue that due to this experience they have, it would be wise to designate them as responsible for the enforcement of the right to explanation under Article 86. And then we have 2 more practical recommendations. The latter one actually based on these challenges that I was mentioning, the technical challenges. So it would be beautiful to have an EU-wide database of DPA's decisions with proper search engine and allowing us to actually scrutinize the enforcement in more systemic manner. And I guess also technologically it would be or it could be less expensive and less complicated than having all these databases that we had to go through to conduct this study. And then finally, also, this is based on our observations while collecting data. Definitely it's worth supporting the cooperation of the DPAs at the level of EU bodies. We have seen some of the DPAs referring on their websites to tools developed by other DPAs. And yeah, these kind of notions we believe that are very much worth supporting and therefore also could be maybe encouraged at the level of the regulation itself, right? By supporting, for example, the inclusion of DPAs in the works of AA board and just the exchange of knowledge and information. And all this you can read about in this paper, which you should be able to access under this QR code, which I will also show in a second again, because before my time is up, I also want to mention that there is so many limitations to this study, which out of which I mentioned some, but what we are trying to do now is to actually address them ourselves as a part of this research project that I mentioned. So we try to develop more qualitative approach to data that we have collected and to collect more of them. So to look more in depth in these decisions concerning AI, we only selected this part of the data set as a core for developing another data set, which would actually scrutinize which provisions were infringed in the decisions and what were the arguments appearing there and so on. This is very much work in progress, so I don't have much to share about this so far, except for maybe an observation, like very initial observation that we have, that actually these general provisions about legal basis for processing and principles of processing seem to be more relevant for these cases than the ones that we could technically suspect as probably important for this kind of issues. So, for example, the ones concerning automated decision making, right? So more about the general ones, less about the more technically related to AI ones. But as I said, this is very much work in progress. So I will hopefully be able to tell you more in like half a year. And yeah, this would be all from me. And thank you very much again for this opportunity. Again, the QR code, this is in open access. So I'm very happy about this. And yeah, thank you.
Thank you. I think you deserved some applause. And also thank you to your co-authors. Congratulations again. I really loved your paper. And I also think, that it was very informative. But it doesn't matter what I think, because this is top policy provocation. So it matters really what Romain thinks about this paper. What does the EDPS say? I believe you also got the AI portfolio, right?
Pardon?
The EDPS also does AI work now.
Exactly. Yeah. And I'm not sure I'm going to say what EDPS is thinking, but I can share what I think, which is already, I guess, a little bit useful, probably less than what EDPS would think. First of all, thank you for the invite. Thank you for inviting me for a provocative paper. You know that I like provocation, so I really think it's a good place for me. I put my glasses on to look a little bit clever, because you know that I'm not an academic, so it's super difficult exercise to, I hope it works. And as you said, I was reading that in the mountain in Morocco, so I really had a remote and distant approach to the role of DPAs in AI. Of course, very interesting, first of all, because you mentioned it, Christina, the EDPS is one of a kind of a DPA, because as you may know, the EDPS is appointed as an MSA under the AI Act to supervise the EU institutions and bodies. That means that we don't have this debate at the EU level at all, since the DPS is the competent authority to supervise AI Act, and therefore is preparing already to supervise the EU institutions and body, with notably the creation of AI unit within the DPS. It was 2 years ago already. Already coordinating what we call a network of AI correspondent, which is a little bit the equivalent of a DPO network, which is already existing at the EU level, where AI correspondent of the different EU institutions and bodies are already exchanging and discussing about how to implement the AI Act in the EU environment, the EU body. So it's not new to the DPS, and it's even more relevant than any other DPA, as you may know. Then I would just go back to the challenges that I identified with having two hats as a MSA and a DPA, because I see that you kind of praise to have these two hats, but let me share with you that it's a difficult political and financial situation as well for DPAs, because the more competence and powers you have, the more resources you need. And as you know, in this time of budget cuts, it's not always easy to get the resources. So be careful what you ask, you might get it, as they say. And it's a difficult situation sometimes. I do also appreciate the way that you tried to identify the decision of and the involvement of DPAs into AI. I think it's an interesting way to do so. However, if I may, I'm not sure, but at the same time, I have no better solution. I'm not sure that the criteria used, like enforcement and guidelines published, are really measuring the involvement of DPAs as such in the AI enforcement. But again, you raise a very important question, and I think it's also a policy question, is the availability of decisions of DPAs. I think we should even say more than that. We can see that neither the GDPR nor the new procedural regulation is addressing this point of, first, the obligation to publish the DPA decision on a website. There is no obligation to publish decision nowadays in the GDPR. Therefore, you have different practices in different member states. For example, the Belgian DPAs is publishing every decision that is adopted, whereas the Luxembourg DPAs has a policy that I'm not sure that I ever understood when it comes to case-by-case publication. Another problem that is also related to this one is the lack of harmonization about the obligation to publish the name of the defendant in the publication themselves. But it's another story which is not even really a concern for you, because whoever is concerned by the AI, you don't really care. But I think it's also important to see and to understand that the lack of harmonization regarding the obligation to publish the name of defendants, in this case the controller, is not even harmonized in the EU. As well, in some member states it's seen as a sanction to have your name published, and in some other member states it seems as a normal course of action for administrative law. Another remark that I wanted to make as well is, yes, you have to rely on other databases, and of course I'm a little bit biased because, as you may know, I was working for NOIB, but I'm happy that you were relying on the GDPR hub, and if I'm not mistaken, you were also relying on the Digital database as well, from the existing one that you know, and enforcement tracker. It's also a little bit of a pity that you have to rely on private resources, sometimes paying resources, to have access to this data as well. On the more governance note, I think you rightly raised the problem of cooperation. We, as you know, and I think you mentioned it in the paper, EDPB always advocated to have DPAs appointed as authorities, as you mentioned in the Annex 3 of the AI Act, at least as MSA for high risk, as mentioned in Annex 3 for law enforcement, at least. That being said, we have limited time, I know, but I want to raise the challenge of the EDPS having two heads, enforcing the GDPR, the EU DPR, and the AI Act. There is no procedure foreseen by the AI Act and the GDPR about the interaction between both functions. Let me be more concrete. What happens if the EDPS, in this case, EDPS has two heads, MSA and DPA, receive a complaint about automated decision-making involving AI? And this complaint is about explainability of the system. Is this complaint based on a GDPR? Is this complaint based on an MSA? Depending on the answer, you will see that the complaint has or has no obligation to be followed by the decision. For example, the AI Act does not provide the obligation for an MSA to act on the complaint, whereas this still debated under the GDPR, but you have a better argument to say that the DPA has to act under a complaint of a DPA. Another challenge, also inherent with the DPA, the DPS work, is how to work with or without a Chinese wall between the units dealing with the AI complaint and the units dealing with the GDPR. Is it legally possible to exchange information between these two units without, as you already mentioned in your paper, which I think is a really good point, a cooperation or at least a procedural basis to exchange information legally, so that this exchange of information between the two units, having two heads, is not challenged by the defendant before court on the basis that, oh, you received this information on the basis of the AI Act, why are you using this to enforce it under the EU GDPR? So that's challenges that we already identified, because we know that controllers will use any procedural ground to challenge this. So that's a little bit of a challenge that we already see with these two hats that we at EDPS already have. So I think it was interesting to read it in your paper as well about that. A last point, I see the link that you make between the right to explanation and the right to have a human intervention and the ADM under Article 22 of the GDPR. But it has to be understood that these two rights they are not even two rights. One is a right and the other one is an obligation under the AI Act. And I think there is too often a confusion between ADM, which is applicable wherever processing is taking place, high risk or not high risk, whether, as you know, in the AI Act, the obligation of transparency and the obligation to have an explanation is not always, is overlapping, but always the same with ADM. So I understand the shortcut between ADM and transparency obligation and human intervention, but it's not always the same. You know, they don't apply to the same system, they don't apply to the same model, and they don't entail the same rights. So again, I understand the link, and I invite you to read when they will be ready, the joint guidelines between the EDPB and the Commission on the interplay between the GDPR and the AI Act, where we will address this issue about interaction between ADM and the right to have a human intervention. You will see that we don't see that as really the same right, and therefore the link is maybe a little bit more remote than what might think about reading the text. But I think this approach is really interesting, of course, and I will definitely send this paper to my colleague at the AI unit, because it's exactly what they are working on nowadays to implement the AI Act within the EU institutions. So thank you again for your work.
Thank you for your really, really good remarks. And do you want to react shortly? Or shall I collect? Yeah. Are you interested to ask a question now about this paper, or you would like to have any other information from the author before we move on to the next presentation? Okay, moderator privilege. I have always a question, and my question is, you already mentioned limitations, so when I was reading your paper, one of my issues is, could there be also some sort of data, let's say that the data isn't skewed because certain countries are very small and have very little AI at that time. So maybe that they never had really a chance. There was never a case in their docket. Is that possible?
Yeah, definitely. I guess it's possible. We're thinking about like recalculating it, taking into consideration, for example, population, but this would also not be a good solution, right? Like we don't have, I suppose, data about how many AI-driven services or tools are available in each country, right? So this would be a good proxy. But yeah, another like problem would be, and this is also something you mentioned, like the resources, because we're also thinking about this, right? To take into consideration the resources that DPAs have as something that we should take into account when assessing their activity. But we didn't have data for the time period that we're looking at. There are some reports based on surveys sent out by EDPS, I think, or EDPB from like 4 or 5 years ago, even more maybe now. So again, not the time period that we're looking at. So yeah, like data availability, I guess, is the biggest problem here. And something that, yeah, one thing that I'm wondering about, like, because I think that many of the issues that you mentioned would be true independent on who is actually designated under the AI Act, right, as a MSA, because, yeah, I guess in some countries it doesn't matter who is designated, the money for the enforcement would not be there anyway. So in this sense, having at least people that to a certain extent are familiar with some of the issues, right, that are regulated by the AI Act might at least give this kind of advantage to the enforcer that might not be there if like an authority that doesn't deal at all with these kind of systems would be designated. So this is one thing, but like from purely legal perspective, I started to wonder whether actually when you have one authority having these two hats, whether the principle of sincere cooperation between two units would apply, and whether, you know, this could be basis to actually exchange this data about the proceedings and so on. So yeah, I have no idea, but just wondering. And I guess, yeah.
Well, thank you, thank you, thank you. You could also send questionnaires to the authorities. I thought, okay, but they don't like that maybe. I don't know. But we are moving on now to the next paper, to the next paper, and that is for Ruoxin, in Beyond Individual Privacy. And you have also a presentation, and I think it's a really fascinating paper, so the floor is yours. Would you like it?
Yeah. So good morning, everyone. It's a great honor to be invited here to meet again after the Leiden's conference. And also it's very interesting because last year, our group organized a panel here at CPDP, which is about the global perspectives of genetic data regulation. So we also talk about the regulation in the European Union, in the US and China, and also some thoughts from the academia. So I think it's a good follow-up with my research. So the topic of my presentation today is time to rethink genetic data governance beyond individual privacy. This one? Okay. So this paper right now is also publicly online and is open access to everyone in the Journal of Law, Medicine and Ethics. And I made a lot of improvements from the PLSC's comments and also from the reviewers. I really appreciate for that. If you have interest, you can read it after the panel. So I would like to begin with something relaxing and news because I don't want to delve into the academic thing very directly. So here is a very recent incident of the UK Spell Bank data leakage in April. So the medical data of about 500,000 participants of UK Bell Bank was found listed on the Chinese e-commerce platform in April for sale. And these data sets were previously shared with 3 academic institutions in China. And after that, very soon, with the assistance of Chinese government, these data sets were taken down from the Chinese e-commerce platform. So even though these data sets were anonymized, but it was reported that a single participant has been re-identified just according to the date of birth and the data of an operation of this participant. So but it's not the first data leakage from the UK Bell Bank. In the past year, there are almost 200 data leakage incidents from the UK Bell Bank. So it's actually not a matter of individual privacy, but also a matter of a national digital infrastructure. And maybe many of you may know the 23andMe bankruptcy last year, which is quite famous around the world. So in March 2023, this company officially filed for bankruptcy in the US, and it sparked concerns because the company holds millions of individuals' genetic data based on its genetic sequencing services. So the implication quickly escalate to the national escalate beyond individual privacy and consumer protection. So the government, so the US government has also a hearing regarding the privacy and national security concerns from the 23andMe's bankruptcy sale. The government considered that a foreign acquisition of such a population-level genetic database may directly pose national security threat. Well, also there are concerns from the academia because such a massive genetic database has a great value and can benefit the scientific research, for example, in medicine, in biosciences, etc. Okay. But the bankruptcy procedure ended in June 2025, last year. So the end of this incident is that the founder of 23andMe regained control of this company through an NGO institution she controls. Well, also I would like to share with you an investigation last year in Finland. So the Finnish DPA investigated the University of Helsinki in earlier last year. So the university purchases genetic sequencing services from a Chinese biotech company, and the university transferred some human genetic resources, like materials and data, to the China-based company. And here, the core issue that the DPA emphasizes is actually not beyond the general or standard GDPR compliance. So the DPA considered that the European genetic data could be accessed by a foreign state or used for military use according to China's domestic law. So as a result of this investigation, the university stopped the cooperation with this Chinese biotech company. And here we can see from this a lot of incidents, we can see the complexities of genetic data governance nowadays. So that's actually the background of my research. And here I would like to ask a question. So this is also the question this paper would like to explore. Is the data protection law still sufficient nowadays, given this increasing complexities? Because if we talk about genetic data in the Europe, maybe the GDPR is the first one to come up with our mind. But in this paper, I draw on existing literature that talks about the multidimensional nature of genetic data in law, and also some cross-jurisdictional evidence from different countries, from different regions. And here I would present this core contribution of this paper here, but I will explain it later, especially the every layers. So this is the core contribution of this paper, and it's a 3-layer diagnostic model for comprehensively understanding the genetic data governance nowadays. So let's begin with the first layer, the genetic data as individual privacy. Maybe many of you are familiar with how genetic data is regulated under GDPR. So I will go through it very quickly. So it's grounded in Article 9 GDPR as one of the sensitive personal data. But in my paper, I argue that the approach under the GDPR, but also in many other data protection laws, is quite individualist and also sample owner focus. So it follows a very strict one-to-one relationship between a person as a data subject and his or her genetic data. And also it emphasizes autonomous control and personal non-discrimination. And it's also rooted in Article 8 ECHR, the European Convention of Human Rights, which is the right to private and family life, but still it's very individual focus. The second layer actually is not usually discussed from the legal perspective, but we see a lot of findings and literature from bioethics and genetics, that is the shared nature of genetic data, which talks about the relational and group interest that the genetic data can have. But actually, it has been already recognized in some existing international and regional non-binding instruments. For example, the UNESCO declarations on human genome and human genetic, and also Council of Europe recommendation, and also Article 29 Working Parties document. Well, it's very interesting to see there is an implicit recognition in the ECTHR case law, which is a European Court of Human Rights. But such a recognition is just occasionally, and it hasn't been systematically developed. So we can see a few cases reviewing the relational feature of genetic data in case law. And a key legal and ethical dilemma for this layer is the protection and balance of individual privacy and with the family's benefit sharing rights, or to say the group's benefit sharing rights. Well, here is the third layer, which moves a little bit more from the individual level and group level. So there is a rapidly emerging trend in the world where the genetic data is no longer just about privacy, but it's not just about privacy, family groups, but also about national interest. So it's integrated to national security, public health, and also economic competitiveness. It's primarily visible in the US and Chinese law, but also we can see other examples like in Mexico, in South Africa, in India, in Indonesia, etc. So China has been considered as a very consistent and assertive jurisdiction where human genetic resources are explicitly recognized as a national valuable asset in the law. So the scholars categorize Chinese approach as the approach of biosovereignty. So it explicitly claims national sovereignty over the genetic resources of the country, including not only the physical samples, the physical materials, but also the genetic data generated from these materials. And maybe you are not familiar with this approach, but here is a concrete example of the influence of this approach. So here is a data availability session from a paper published by a group of Chinese researchers in 2023 in Nature. And it's about a pan-genome reference of 36 Chinese population. And before this paper was published, they got a permission from a Chinese biosecurity regulator just to release the research data in order to allow for publication in this journal. And also there is a recent policy and legislative trend in the US. I would see it's a kind of a reactive biosecurity approach largely due to the geopolitics. So we can see the Biosecure Act, which was approved in December 2025 and to become a law. And it focuses on the biotechnology supply chain and also prevent the access to the Americans' genetic data by foreign governments. But in this paper, I also touch upon some relevant initiatives in Europe. But I found that these initiatives emphasize values for public health and economic competitiveness, and mainly through the digital or data infrastructure, for example, the 1+ million genome, the EHDS regulation, and for example, in the UK, they have the biological security strategy, and also they have the Genomics England, Genome UK strategy. So we come back to this model. So it's a diagnostic model to comprehensively understand the governance of genetic data nowadays. So the individual layer refers to protecting genetic information as sensitive personal data. And the relational or group interest layer refers to safeguarding a shared group and familiar interests, not only privacy, but also other interests. And the strategic layer refers to managing genetic data as a kind of national public health and public security, national security asset. And it aims to, so my intention in the beginning is to offer a practical framework, especially for private sector, because my research focus on the scientific research, the use of genetic data in scientific research. But I also want to hear some thoughts from the policymakers' perspective today. And it aims to help to navigate this competing or complex legal and ethical interests in the use of genetic data, especially the potential governance risks that go across national borders. And for example, the key beneficiaries could be the direct-to-consumer genetic testing sector. Perhaps they operate in different markets, in different jurisdictions. And also for the international scientific research collaboration, they may address the different jurisdictions' requirements about data protection, about other relevant laws that are applicable to genetic data. And also, for example, the multinational biopharmaceutical companies that managing global R&D. Well, I also want to acknowledge some limitations in my work. So it aims to provide a comprehensive analytic lens. So it's not providing a one-size-fits-all solution. So I prefer to remain this model as descriptive rather than prescriptive, because the law in different countries are different and have different legislative purposes. So for the strategic layer, I would acknowledge that this is actually and largely based on the geopolitical regulatory responses from the major powers in the world. So maybe for this layer, I need to collect more evidence from other jurisdictions and then to elaborate the meaning of this layer. So in the end, I would say this model could be dynamically updated according to the latest technological and jurisdictional development. So that's all for my presentation today, and I very look forward to hear from the policymakers' perspective.
Thank you so much. It was a very, very interesting presentation and paper, of course. And I really wonder what you made out of that, Roma. How does that resonate with you, this paper about these different dimensions of genetic governance?
Thank you. Thank you for the paper. Also very interesting, especially in the mountains in Morocco, when you you realize that the gene pool is sometimes some valuable asset for some population. Reading your paper, I had two things that just came to my mind, and I'm sure you came across these two stories. The first one is the Icelandic saga in 6 years ago when I made some research about, but I heard that the Icelandic government has sold the genetic data of the entire population to a pharma industry, to La Roche, I think, for, of course, millions or billions of dollars, because they specifically had this really specific ethnic and genetic characteristic in the Icelandic population, because there was not a lot of mix with other populations. So you can see that there was something at stake as well. And I was also always surprised to hear this story, considering the very high awareness of the Icelandic people about privacy and data protection. You can see that there was like a tension between a country very well known for protecting their privacy quite efficiently and selling the entire genetic pool to a pharma industry. Another thing that I had came to my mind was the prohibition in some countries, especially France, to use this, genetics test that you can use, especially in the US. And I was always wondering whether these laws prohibiting the use of such tests, especially in France, was, and just a provocative question, because I know it's a provocative panel, whether these laws were in line with the GDPR, because they basically prevent you from accessing data about you. And I understand that the reason why this genetic test was prohibited in Poland and in France and other countries as well was basically maybe kind of a sovereignty, as you mentioned, as a third layer. I understand it's a third layer in your paper, but also to protect the individual from the lack of medical support when you receive the data, or mental distress, or even the protection of relatives, of course, considering that you might be born, especially in France, under, as we say, sous X, so without a mother and a father, and which is contravening to the law preventing you from finding your father or your mother in this case. So it was also interesting to see the tension between your right to have access to your data and the way that governments trying to prevent you from having this right access under the GDPR. On another note, you will, I guess, have seen that EDPS and EDPB were not really vocal about genetic data. And I'm since at EDPS, I'm quite involved in the health data cases, especially the biotic and the scientific research guideline that I'm sure you've read. They were adopted a few months ago at EDPB level. It was guidelines for scientific research. We touched upon the very specific issue of genetic data, and I saw some, because I love to see what the doctrines and the authors are writing. We were criticized at EDPB for not going too far enough, because especially as you mentioned in your paper, the genetic data also relating to other people than yourself, and especially your family, or a community or an ethnic community that can be also impacted by the result of genetic data on your ethnic community. And in this regard, I just observed that in the EDPB guidelines, we made a reference to the information to inform some specific ethnic community about genetic research that were performed and having an impact on them. So you have to inform beyond the Article 14 obligation under the GDPR about the methods used for the research or the outcome of the research expected. So you could see that it was already kind of a concern in the EPB guidelines on scientific research, but we didn't go that far to protect groups of people. Why? Because as you mentioned rightly, GDPR is right-based, and it's just here to protect individuals, and there is no collective dimension in the GDPR to protect group of people. And the last note, it's also very difficult from a DPA perspective to enforce GDPR rights representing a group of people. As you know, GDPR again is complaint-based or ex officio based, but it's not the natural DNA, if I may say, of the GDPR to protect groups of people. So it's exactly a loophole that is not addressed by the legislation right now, and I totally agree with you. That's what I would have to say on this paper. Thank you.
Thank you very much. It was still really a very rounded comment. I couldn't have done that any better. So thank you very much. Would you like to reply to what you have heard? And do we have any questions in the audience about this paper? Would you like to ask something to the author or about this research? Or you have anything you would like to contribute? Not really? Yes? Can we have a microphone there? We have to hurry a bit.
Hello, and thank you for the presentation and the paper. I'm Johan from University of Paris 8. My question is a question of curiosity. I'm not necessarily expecting that you have the answer, but I'm just asking just in case, because this is a subject you are studying. So I was wondering if you had the time to do a comparative study with the law on genetic data and these types of online services also in other countries beyond Europe, because I'm curious as to what the different rules might be and the different ways in which it can be approached. Yeah, I mentioned, of course, Europe and China, but I was just wondering if you knew also from other jurisdictions, and yeah, maybe you don't because it's not the topic of your research in your paper, but I'm curious, so I'm just asking in case you have something.
Okay, I'll keep it short. So my PhD research focused on the comparative studies between EU law and Chinese law. And last year, we also published a paper focusing on the definition of genetic data in EU law and Chinese law, and which was published in the International Data Privacy Law Journal. And if you have interest, you can have a look because it elaborates a lot of differences between the frameworks, the definitions, the legislative philosophies. And for other jurisdictions, I may have time to do more research after my PhD because they are also quite interesting, and especially the emerging frameworks in the US right now, and also in other developing countries, which also have the similar national strategy concerns over genetic data.
Thank you. And I realized that we are starting to run into the time of the last presentation. So without further ado, Dave, please introduce us to the Beyond Schrems paper, the unresolved tension between US government access and the GDPR.
Thank you, Christina. Good morning. My name is Dave. And for the next 15 minutes, I'm going to be talking to you about the tensions between US government access and the GDPR. Given the title of today's panel, I will do my best to be provocative. But first, I'll introduce myself. As I said, my name is Dave. I work as a researcher for the Cloud Legal Project at Queen Mary, University of London, and our research is funded by Microsoft. I also teach. I teach both at Queen Mary and at the LSE. And the paper I'm presenting today is based on work I did together with Professor Christopher Millard, who's here with us today, Ian Walden, and Ulrich Wuermeling. As I said, our paper is all about the tension between US government access and the GDPR. And we focus specifically on cloud services. So by way of example, let's consider a specific scenario, right? Let's say we have a European organization that is using a cloud service provided by a company that is the European subsidiary, which is wholly owned by a US parent company, right? So this could be Microsoft Ireland or Google in Ireland, wholly owned by their respective parent companies in the US. So what we have is a business-to-business relationship, and in the course of using the service, the European customer discloses personal data to the provider. And let's say the provider commits to storing that data on servers in the EU. Right, this is a fairly common setup for cloud services. Now let's see what happens when the US government wants to obtain access to that information. And that could be because a prosecutor issues a production order seeking information as part of a criminal investigation under the Stored Communications Act, as amended by the Cloud Act, or it could be because the NSA is looking to obtain foreign intelligence under FISA Section 702. Now importantly, under both of those powers, it doesn't matter that the data are physically stored in the EU, right? The US government can issue production orders targeting data which are stored abroad. And so to comply with that order, the cloud provider might simply have remote access to the data stored in Europe, in which case they can directly access it and hand it over to the US government. Or, if they don't have such access, they can simply order their subsidiary to hand over the data and then hand it over to the US government. So these are the kinds of scenarios that we're concerned about in our research. Now, of course, this is not new, right? There has been a long-standing discussion of US surveillance powers and their impact on European fundamental rights ever since the Snowden revelations in 2013. But it is a hot topic at the moment, especially amidst the discussions around European digital sovereignty and the concerns about Europe's widespread reliance on a handful of US cloud providers. So survey evidence indicates that some 70% of cloud customers are concerned about their data being exposed to foreign law and accessed by foreign governments. And that's driving demand for what are sometimes called sovereign cloud services. So a survey conducted last year said that the top 2 reasons European organizations mentioned for adopting sovereign cloud were, first, to protect against foreign production orders, and second, to comply with national and regional legislation. And it's precisely that tension between foreign production orders and the need to comply with European legislation that is the topic of our research. More specifically, we ask, can a cloud provider comply with its obligations under the GDPR when disclosing European customer data to the US government under US law? And so in today's presentation, I want to highlight 2 particular areas of tension. The first is the issue of a cloud provider processing data without customer instructions. And the second looks at the question of what lawful grounds the provider can rely on when making the disclosure. I'll argue that both of these present compliance challenges. At the end, I'll briefly mention a few potential solutions. So let's start with this issue of customer instructions. And the problem here is that the provider was initially acting as a processor for customer data, right? They were processing this data on the customer's behalf at the customer's instructions and in order to provide the service. So the customer is the controller, the provider is the processor. But when it receives this US production order, the provider now starts processing that same data on its own behalf for a purpose that it set itself, right? It's no longer acting on customer instructions, it's acting for the purpose of complying with US law. And so for the purpose of the disclosure, the provider is acting as a controller. Now, Article 29 says a processor can only process data on controller instructions unless processing is required by EU or member state law. That is EU or member state law, not US law, right? So we have an issue here. And this issue is not resolved by the existence of the EU-US data privacy framework and the associated adequacy decision, because that merely permits commercial transfers of data to the US. It does not create a requirement under EU or member state law to disclose data to the US government. So what does all this mean in practice? Well, we can look at what current providers are doing. And we can look at AWS's data processing agreement as an example. So AWS says AWS will not disclose to any third party any customer data except as necessary to comply with the law. That's the law, not EU or member state law, because obviously AWS knows that it will also need to comply with orders issued under US law. They add that if compelled to disclose customer data to a governmental body, AWS will give the customer reasonable notice, unless AWS is legally prohibited from doing so, which they typically are under US law and certainly are under FISA Section 702, because those orders must be complied with in full secrecy. So what does all this mean for customers? Well, it means that customer data can be disclosed to foreign governments under foreign law secretly, that is without the customer's knowledge, without customer instructions, and in a manner that is not required by EU or member state law, which would appear to be a breach of Article 29. So that's what I wanted to say on customer instructions. Let's have a look at lawful grounds. So here our analysis starts from the simple premise that the act of disclosure to the US government is an act of processing. And that means it requires lawful grounds for processing under Article 6, which means that the cloud provider, as the controller, needs to identify lawful grounds before making the disclosure. Now, it's true that Article 6.1c refers to the need to comply with a legal obligation as a lawful ground, but that applies to obligations arising under EU or member state law, not US law. And again, the DPF is irrelevant here because it does not provide a legal obligation to disclose to the US government. So we can't use that. Of course, we could turn to legitimate interests under Article 6.1f. And it's true that the cloud provider has a legitimate interest in complying with a validly issued US order, because otherwise they're subject to sanctions under US law. But we need to weigh that interest and balance it against the data subject interest in not having their data disclosed to a foreign government under foreign law. And so we find ourselves in the familiar balancing of interest test under Article 6, which of course can only be done on a case-by-case basis. But we identify two factors that will typically be relevant. The first is the question of the level of safeguards under US law that protect European fundamental rights. And this is where the DPF and the associated adequacy decision are arguably relevant, because at least in the Commission's opinion, US law provides for essentially equivalent protection to EU law when it comes to protecting European fundamental rights. And that is a factor weighing in favor of disclosure, right? The argument would be that US law already provides for European fundamental rights. Of course, that is a contentious point, right? The Commission believes it does. They have been wrong before. The CJEU has confirmed in the Letum ruling that they are right this time, but the ruling is under appeal. So we'll have to wait and see. But it's certainly a factor that goes towards the balancing of interests. Against that, on the other side, we need to weigh the nature of the data to be disclosed. And so a cloud provider can do this. They can look at the data before disclosing them and look, for instance, whether they contain special category data, in which case they'll also need to meet the more stringent requirements of Article 9. They can also look to see whether they'll be disclosing children's data or other categories of more private data, such as financial or location data. In all of those cases, the presence of those more sensitive types of data would be a factor weighing against disclosure. So what does all this mean in practice for data subjects? Well, as things stand, their personal data can be disclosed to the US government, and they can be subjected to surveillance by the NSA, subject only to limited safeguards under US law. And that is potentially a breach of Article 6 and 9 of the GDPR. So to sum up then these two areas of tension, we've spoken about the problem of processing without controller instructions and the question of what lawful grounds for processing would apply. These present compliance challenges, and to close my presentation, I'll mention a few possible solutions. So Dave, what should cloud providers do? I've got two quick answers. The first is that cloud providers need to obtain clear instructions from their customers to disclose customer data to the US government under US law. Right? In that case, the customer will become a joint controller for the disclosure, and that will solve our problem under Article 29. Now, this might not be particularly commercially attractive to cloud providers, right? I started the presentation by saying that some 70% of customers are concerned about foreign government access. They probably don't want to instruct their cloud provider to hand over data to the US government. But that is the reality of using a cloud provider subject to US jurisdiction, and cloud providers should be transparent about that in their data processing agreements. It also means that the customer becomes liable for the disclosure and ensuring its compliance with the GDPR. And customers might be concerned that the disclosure does not, in fact, comply with the GDPR. In which case you might ask why they are storing sensitive personal data with a US cloud provider in the first place, especially if they're not applying techniques like anonymization or end-to-end encryption to further protect the data. So that's my first suggestion. Controller instructions are simply required under Article 29 of the GDPR, and cloud providers should get them. The second point is that cloud providers really should only disclose personal data to the US government if they are sure they have legitimate interests under Article 6 and can meet one of the exemptions under Article 9 for special category data. Typically, I think that means they will need to refuse to disclose to the US government any special category data which are subject to the production order. They can do so because they can challenge a US production order based on the principle of comity under US law. So they can say, if I comply with your US order, I will breach my obligations under European law, and in this instance, European rights should prevail. That's not certain to succeed. It may very well be that a US court decides that, in fact, US interests in national security especially should prevail, but cloud providers should at least commit to fighting on the basis of comity. I also understand that cloud providers might be hesitant at the moment to pick a fight with the Trump administration, which has been unpredictable in its dealings, even with US businesses. But I do think presenting these challenges is the best way for cloud providers to comply with both US orders and their obligations under the GDPR. and to show European customers and European citizens that they are serious about protecting European fundamental rights. If you'd like to read our paper, it's up on SSRN. If you're interested in our research, do add me on LinkedIn, and thank you so much for your time.
Thank you. That is a really fascinating paper because it goes through all these laws and it shows how complex that is. And I think I've never read a paper that was so clear about these tensions. So for that, thank you. Yeah, and then let's see. What did you make out of that, Roman? Do you think it's relevant for policymakers?
Oh, definitely. More than definitely. And I see my colleague, I have an easy way out because you know that, Thomas, I will not throw you under the bus, but I think I will. As you know, EDPS was quite involved, of course, in the work of the EDPB for the assessment of the DPF, but also the adequacy framework as well. So it's really relevant for our work, especially as the advisor for the EU institutions as well as the Commission. We are in the first line to assess the framework negotiated by the Commission, especially the DPF. Personally, I was also, as I said, working for NOIB, and you know that Schrems is a common name that I was hearing every day when I was working for NOIB as well. So, and I thought that the title of the, just for the little joke, the title of the paper was like, what is the aftermath of Schrems 2? And I was like, who needs to write 70 pages to know that after Schrems 2, the logical outcome will be Schrems 3? But I must say that this paper is amazing. I really appreciated the way that you just reintroduced FISA and Executive Order 1233, which is not a common standard knowledge for everyone, right? Even, I would say even for me, I'm not so familiar with that because you forget very easily what is the US law saying. So really relevant for the work of the DPS for sure. As I mentioned you just before, it's also very relevant because you also mentioned a paper that I was also directly involved is the paper about the Danish request for an opinion about whether the lack of instruction from a controller to the processor to disclose information to non-EU governments was supposed to be an instruction under Article 29. So we were really debating this question a lot within the DPB with, I would say, diverging views from DPAs about the same question. So I think it's really welcome to have this kind of paper to enlighten different views on whether disclosure to a government is instructions or not. Also very relevant, I think, is the mention is just two remarks that I have personally. You also mentioned, and you're not the first one to mention it, and I'm very amused to see that in some papers. We have 4 minutes. You mentioned that there was a lack of clarity of the material and territorial scope of the FISA and one. Do we agree on that, right? That's interesting to read. Because if I can refer to the EDPB document on the essential safeguard that was adopted together with the paper on the safeguard on the aftermath of Schrems 2, what to do with the TIA, and this first paper, which is adopted simultaneously, as you know, is usually disregarded. But one of the first conditions that is reminded by the EDPB is that the law must be clear, accessible, and intelligible. And what I fail to see is that it seems that the scholars, especially in the US, seem to disagree about the scope of the powers of FISA. And in my opinion, again, my very personal opinion, I'm still surprised that you go further in the discussion, because if the law in the US seems to be subject to so many debates about the scope and the clarity of what the US government can do with this law, I think we should even stop the discussion there, because the essential guarantees paper of the EDPB says that if the law is not clear enough in the US to know what the US can do or not, it's end of the game. I'm very provocative discussion, huh? And that's something that I wanted to raise as well, because you see as well in your paper that you confirm that the scope is not clear even for the US scholars or even the US government. Can you subpoena the EU branch of, that is not clear. So if the law is not clear, how can you make an assessment of the law? That's the first remark. The second, and I mentioned it to you as well, you disagree with the EDPB, but I have to agree with the EDPB. I don't have to, because trust me, I would also share my diverging views, but it was also debated a lot that legitimate interest could not be used for obvious reasons as well. to circumvent Article 48 of the GDPR. I don't want to be too technical, but I think it's difficult for us to accept that legitimate interest can be used as a legal basis to process the data for transfer to outside of the EU, because you would just then circumvent the very Article 61C that you mentioned. So you would apply 61C for EU request, but 61F for US request, which in a DPA DNA, again, would not make sense to treat this two requests differently. And since we are short of time, I would not go further, but it was really interesting and I have so many things to say, which is also a nice way to cut it there, I think. Really, really relevant. Yeah.
Thank you so much. I have to apologize for my somewhat too lax timekeeping during this panel. Blame it on the Mozilla party. But it was really a pleasure to have you all here, to hear from you. What you got is really a rich brush up through 3 different topics, and I hope you enjoyed that also a little bit. Thank you all. If you have questions, you will find us, but we have to go out of the room for the next panel. Thank you.